Is the Advocacy Counsel for the Law and Security Program at Human Rights First. She was an observer to the Military Commission's proceedings at Guantanamo Bay in that capacity. She's also worked in Cambodia at the Documentation Center in Phnom Penh, and she did a stint in eastern Chad with the Darfurian refugees in connection with a U.S. State Department investigation. To my immediate right is Nick Rostow, who serves currently as University Counsel and Vice Chancellor for Legal Affairs at the State University of New York. That's not the least challenging job he's had. He served in several administrations as Special Assistant for National Security Affairs to Presidents Reagan and George H.W. Bush, and legal advisor to the National Security Council under National Security Advisors Colin Powell and Brent Scowcroft. And he's also worked as the General Counsel and Senior Policy Advisor to the U.S. Permanent Representative to the United Nations in New York. We also have Matthew Waxman, who's Associate Professor of Law at Columbia Law School. He is an Adjunct Senior Fellow for Law and Foreign Policy at the Council on Foreign Relations and the Hoover Institution Task Force on National Security Law. He's a member there. He worked at the State Department in a previous government stint, several of which. He was Principal Deputy Director of Policy Planning at State, and then Deputy Assistant Secretary of Defense for Detainee Affairs, very relevant for this discussion, Special Assistant to National Security Advisor Condoleezza Rice. We also have Laura Olson, who was until recently attached to the ICRC. She now is Senior Counsel at the Constitution Project and President of Black Letter Consulting. Black Letter, not Black Water.
Thank you for the clarification.
Consulting. She was a visiting scholar at Notre Dame Law School recently, and she served as legal advisor to the ICRC regional delegation in Washington, as well as legal advisor to the ICRC headquarters in Geneva. And finally, we have Gregory Noone, who is Assistant Professor of Political Science and Law at Fairmont State University, but he also keeps his hand in reality as a Navy judge, advocate, reserve captain, and the comments here today obviously are not those of the government, but of yours.
My career will thank you.
He was a Navy JAG officer and was acting head of the International Law Branch and the Foreign Military Rights Affairs Branch of the JAG International and Operational Law Division at the Pentagon. So we have a great team to talk about our topics today. And I want to sort of divide out a little bit of what we're talking about. Our overarching theme, which we got a great setup piece from the last questioner, and I thank you for that, is dismantling Guantanamo Bay. And this raises nuts and bolts issues, this raises theoretical issues, this raises political issues, and legal issues. And the subunits of our discussion are continued detention and repatriation. So let's start with dismantling Guantanamo Bay. How do we go about this? There's been lots of op-eds on this, what to do with Guantanamo Bay, what to do with the detainees, what to do with the facility. Some of you probably read my piece on Jurist, that we just go ahead and after Guantanamo Bay is emptied of the detainees, we convert the military facility into a climate change research station and take a sort of a PR jiu-jitsu move and turn what is a PR disaster into a PR success, moving into the Copenhagen negotiations to scrap Kyoto. Matt has had a great piece in the Washington Post on what to do post Guantanamo. So there's lots of things out there, and I guess I want to start with Nick, who has the most extensive government experience with us. What are some of the practical problems that are faced with closing down a facility like this?
Well, let me begin by making a few observations in light of the last panel discussion before I attempt an answer to that question. It is 9/11. Suppose there's a terrorist attack later today or tomorrow. Are we ready not to avoid the mistakes that were made in the wake of 9/11? That's one question. Secondly, it is very, very dangerous to terrify a great power. And I have a psychiatrist friend in France, and when I visited her in the spring of 2002, and said, this administration views the world through the prism of 9/11, she said, you people are pathological. This is crazy. And yet that is what happened. And I'm not sure we're ready to handle a new terrorist attack in the sense of preserving the rule of law, handling it within the rule of law any better than we did the last time. And I think that that's a matter of serious worry. The good thing is that at many times in the history of the United States, the country has gone off the rails legally in some way, but then righted itself. The Supreme Court was famously scared to death during the Civil War and immediately afterwards. Didn't know if it was going to be hit by a steamroller. And it recovered its self-confidence and reaffirmed the rule of law, most notably in ex parte Milligan. When the federal courts are open, you use them. The country went off the rails during World War II, interning American citizens, and it righted that. We've gone off the rails, and to me, the goal should be to get back to the Geneva Convention norm. Anybody who bothers to read the Geneva Conventions, they are very readable, and they tell you exactly what to do. And while the technological context of terrorism today is different from what it was in the 19th century or 1939 or 1949, it's not a new phenomenon. Now, what I think we need to do to close Guantanamo, and it's unfortunate that it's become synonymous with all that is evil. There's a new book by Louis Begley called Why the Dreyfus Affair Matters, and he says Guantanamo Bay is America's Devil's Island. That's absurd. I was there last week. It's just absurd. It's a very complicated situation there, but it's not Devil's Island by a long shot. It's not even the tombs in New York City. There's a defendant, a former inmate or detainee of Guantanamo who's waiting in the Metropolitan Correction Center attached to the federal courthouse in New York City, awaiting proceedings, and he sent a message back, for God's sake, stay in Guantanamo. Don't do anything to get yourself shipped to the United States. It's not clear that U.S. prisons, state and federal, could pass the test of Common Article 3 of the Geneva Conventions. I think we need to prosecute a release. And my view is rather simple-minded. The Geneva Conventions tell you who is and who is not a combatant. If you're not a combatant, you're a criminal. A battlefield is not for tourists. It is an exception to the rule against killing. Combatants are privileged. They meet the standard for being a POW. They are allowed to engage in war. If they don't, they're not allowed to engage in war, and to engage in war is a crime. It is murder. It is accessory to murder. And sorry, you're an accessory to murder. You can't just wander around a battlefield out of uniform. Not allowed. And one of the things that the prior administration got itself wrapped around the axle was whether or not the Geneva Conventions apply only to international or armed conflict. In effect, the federal government applied the Geneva Conventions. They didn't exist, but the rules during the U.S. Civil War. It treated captured soldiers as prisoners of war. It didn't treat them as criminals. So there's a lot of, you can write a lot of interesting law school exam questions on this subject, but it really doesn't help you get where you want to go. And so my view is we prosecute a release. If we don't, if what we know and how we know it cannot be used in court, then we let the person go. The person then throws a bomb, we prosecute, we kill. The problem the consequence we want to avoid is where our soldiers stop taking prisoners.
I want to take a riff off of what you said earlier, and that's the question of prosecute or release. There's an old Latin phrase, aut dedere, aut judicare, and Jordan's written about this, and Sharif has, and I have. And there's some question as to whether or not this duty to prosecute or extradite exists in customary international law, maybe for some crimes and some not. But I'm interested in finding out what the rest of the panel thinks about that notion. You know, if there's a duty to prosecute or extradite or prosecute or release, shouldn't we be applying that?
I could jump. Yeah, sorry, it's on. Sorry, I'm not used to this technological. Usually that's referred to, or when you think of that obligation, it's with war crimes or crimes against humanity, so specific violations. But not all of the rules in the law of war, when they're violated, amount to a war crime or a grave breach. So I would say there's not necessarily an obligation in all cases that you would have to prosecute the individual.
More than that, I mean, clearly in this case, there are a good number of the detainees at Guantanamo that are not ought to have committed necessarily any violation of the laws of war. I mean, I think it's 29 out of the 36 cases that have been considered by the district court thus far have been determined to be unlawfully held. So certainly those individuals, the U.S. would have no obligation to prosecute or extradite. What they have an obligation to do is to find a suitable solution to dispose of those cases that's in line with the rule of law.
If I could just add before we go too far, because I would like to comment on something Nick said as well, but on Devon's point, again, this is my personal opinion. I'm not here representing anyone or any entity that I'm affiliated with. I think the government has lost a lot of these habeas cases because I think the defense counsel have done an excellent job of bringing the better cases forward. I think some of these cases will be government wins, and it's a good strategic plan, but I think there'll be some government wins in the offering. So I think the defense, kind of that amorphous defense, is on a roll, so to speak, and I think they've done a good strategic movement on that look, we've won 29 out of 36, but I think there are better government cases in the future on the habeas. But just to go back to what Nick said, and Nick, I realize where I recognize you from. You were sitting at the next table for me in the Gold Hill Galley last week at Gitmo. You had a nice little table with a tablecloth on it. The rest of us had tables without tablecloths on it. So you were absolutely a distinguished visitor. Actually, that galley wins many awards for its excellent food. The Guantanamo Bay is, in fact, an incredible facility. It is a model facility. And anyone who's spent any time in corrections or has represented people and been to the tombs of the Boston Municipal Court, you would be amazed at how good of a job our men and women are doing down there and the facility itself. In many of the camps, they're only in lockdown from midnight to 4 a.m. They literally have free reign. Again, obviously there's a big fence around the outside, but they literally have free reign of the yard. They get 6 newspapers from several places around the world delivered daily. They have movie channels. They have access to news, to TV. They're taking art classes, language classes. You would be very impressed with what is put forward. So I just want to put that out there because it goes back to what Mike Newton was saying about debunking some of these myths.
But let me just add, and still they regularly spray the guards with urine and smear feces, so it's not pleasant guard duty.
No, and in fact, in World War II in Nuremberg, our guards were only on duty for 4 hours at a pop. Our guards down there are on duty for 12 hours a pop. I mean, they're doing an amazing job and are regularly faced with that kind of item.
And of course, they have free health care.
Yeah.
Oh well, we've done literally hundreds, and I'm just trying to educate people because I was in the medical facility and the doctor said we have literally done hundreds, if not over 1,000 medical procedures.
Yeah.
Every single one of them has had great dental care.
Can I just jump in?
Yeah. Well, so I was going to say, I mean, first let me thank the organizers of this conference and the sponsors, because it's been absolutely excellent so far. I do have one complaint, though, that I want to begin with up here, which is that photo as the background for a discussion on Guantanamo. It certainly as its current state and its future. I think
that facility is overgrown.
In weeds.
Yeah. And there are a lot of us in this room who have spent a lot of time at Guantanamo, and that is not an accurate depiction. But the fact that it's used, I think, does raise important issues that Nick alluded to and that the previous panel did, which is that, accurate or not, there are now some indelible perceptions, I think, that are attached to Guantanamo. One of them is a quality of treatment issue. I think it in much of the world is associated with mistreatment. I think that is a problem that has been largely solved. The second perception, though, is that Guantanamo is indelibly linked to this idea of keeping detainees beyond the full reach of the law. And that's the problem that has not really been solved. And I say it's indelible because I think it will be impossible to solve that problem without shutting down Guantanamo. The question then is in my mind, less an issue of where geographically are you going to hold them other than Guantanamo, so much as what legal process are detainees going to be provided if they are going to be held outside of the normal criminal justice process.
I think, Matt, what you're getting to is the notion that maybe this discussion was starting to take, and that is indefinite detention is okay if it's comfortable. And I don't know if you were going to go there or not, Laura.
The panel wasn't really supposed to be on treatment issues per se, so I think Matt did a great segue. It's hard to bring it back, but I just want to make one comment that many of the things you mentioned were a long time in coming at Guantanamo, and I'm not sure, although I haven't been there in quite a while, that everyone has those conditions. And maybe just in general to the audience, and the only point I would make is generally under the law of war, if that applies, and if you are holding someone, you're interning them. They have not yet been maybe charged with a crime or even convicted of a crime. So the conditions under which someone should be held, the standard should not be a maximum security prison. So that's the only comment I wanted to make.
Well, and one of the things that we're supposed to talk about in this panel is the challenges of continued detention.
Right.
So as we know, President Obama really has kind of bifurcated this issue. He came into office in January and signed an executive order that he was going to close down the detention facility, but that he would review the detention policies and that sort of thing. And here we are in September, and that deadline's fast approaching for the physical space. But he hasn't taken off the table continued detention. And in fact, he's played around with the idea of fixing the commissions and that sort of thing. So I suppose the first question that we go to in this subunit of our panel is what should be the focus or the standard of preventive detention that's going to continue?
Well, yeah, I mean, maybe the question that we should ask before that is it wise to pursue any system of continued indefinite detention?
Why don't you answer that question?
Great question.
Well, I think it's sort of what we've been discussing thus far is that it's not the Guantanamo facility that's the problem that has created become this symbol that is clearly detrimental, that has hurt the United States' reputation, that has hurt our counterterrorism and counterinsurgency efforts, but it's the policies at Guantanamo that were the problem and that have continued to be the problem. And I think that there is a risk that by transferring detainees to the United States and continuing to hold them indefinitely without trial will simply serve to prolong the legacy of the failed detention policies that created the negative mark on the United States reputation that Guantanamo came to represent.
So you think that severing continued detention from Gitmo won't save us from removing this blemish, and those photos, which, by the way, your moderator did not choose, that are indelible, as Matt said.
I think by many,
image.
it will be perceived as simply transferring Guantanamo, not closing Guantanamo,
right,
if the detainees continue to be detained without trial. And I think this is this is a serious concern, particularly if we're going to continue to look to our allies to help with some of the individuals that we do want transferred out of Guantanamo and that we don't believe should be charged. I think if you look at the June agreement that was reached between the European Union and the United States about establishing a framework where many of our European allies have agreed to take in detainees, they made it very clear that they're going to be looking at how we deal with the rest of that population, and that will affect their willingness or lack thereof to take in additional detainees.
Yeah, Greg, you wanted to respond?
No, I just, first of all, I agree with Devon, and I think we all agree. I mean, Guantanamo Bay has caused us a great deal of pain, real and imagined, in all our efforts and all our spheres. Both President Obama and Senator McCain were saying, I'm closing Guantanamo. I think everyone was on board with that. I'm on board. We're all on board with that. Of course, then what do? Because you don't want it to just be moved north. All right. So, I don't know if everyone knows. Maybe they do or not. It's been in the newspapers, but there's the review panel that's looking at every single one of them individually. Everyone's getting one last look that they're looking at them. And on this panel are 6 entities. You have the Department of Defense, the Joint Chiefs of Staff, DHS, DOJ, CIA, and DNI. Okay? And those entities are looking at each individual. And we have about 226 down there. They have gone through just about half, but really less than half. And what they're doing with these individuals when they review their files, review the case, what they're doing is they're deciding whether to move them over to the prosecution bucket or bin, whatever you want to call it, the transfer bin, and that gets into our relations with our Europeans, everyone else really, as far as people taking some of these folks in, or release. And then that last one, which the President mentioned, which is where we're going with this, is Category 5. In his archive speech, he laid it out in 5 categories, and Category 5 happened to be the long-term detention category. And that's going to be where the rubber meets the road for what the administration decides to go forward on with respect to moving this process.
This sort of a 6-party review mechanism is kind of a CSRT on steroids. Right?
Yeah, it's kind of a super review. Super review. One last look, and we're going to give everyone one last look at all this. And,
well, what does international humanitarian law say about continued detention? Laura, do you want to?
Yeah, I found it interesting in the previous panel. They started discussing this a bit. The law of armed conflict obviously applies only if there's an armed conflict. So if there really isn't one, we shouldn't be talking about it, right? Because it permits extreme things to happen because it's an extreme situation. And then there was light.
I think God prefers the ICRC position.
And much of what was discussed were in the previous panel were the Geneva Conventions, which mainly the provisions apply only in an international armed conflict, which is why they were talking about what kind of conflict it is. So at least in international armed conflict, the law of war says, yes, you can hold combatants as prisoners of war till the end of hostilities, because we want to neutralize them and we want to win the battle. But what no one has mentioned, and most of the time you don't hear the government talking about this, and you actually don't even hear the courts talking about this, is that in international armed conflicts, civilians can also be interned. And again, I use the word intern because it means they're not charged with the crime. It's just that perhaps they pose for imperative reasons of security due to the armed conflict, you need to hold the civilian. And they cannot necessarily be held till the end of hostilities like a combatant could. They are required to have a review every 6 months. So even in the previous panel when it was mentioned, there's been no such thing as periodic reviews throughout history. Well, yes, there always has been. Since 1949, when the Fourth Geneva Convention on Civilians was created, they have to have, civilians are entitled to review every 6 months. And if they're found no longer to be an imperative risk to security, they have to be released, even if hostilities are no longer going on. Now, trying to be brief here. And to cut to the chase here, though, the whole question is, well, if it's not an international armed conflict, which is, I guess we could all agree what Hamdan said, because even if we don't all agree it's a non-international, and maybe it's a new type of conflict that we have heard, the court basically said you can only have an international armed conflict if it's between states, and Al-Qaeda's not a state, so at least we know we're not talking those rules. So what does the law of war then say about internment? And in fact, it doesn't say anything. And what has happened is there's lots of talk of by analogy applying the law of international armed conflict to this situation, which even the law of war encourages to do, but there may be reasons, because of logic, that this is not a good idea to do it. And then I will end on this, because there's more discussion to happen. When it has been applied by analogy, as I already mentioned, the courts and the government have only been talking about the Third Geneva Convention related to prisoners of war, which means the person can only be held if they're a combatant. And there are other ramifications of being a combatant, and we can talk about that later. And somehow the Fourth Geneva Convention has never been brought into the discussion.
Well, and of course, that's, the courts are flailing about because there's not any current legislation coming out of Congress to deal with this.
Yeah, but they've been doing pretty well, I would say.
And should there be? I mean, maybe that's a setup question for you, Matt. I don't know.
I'm sorry,
Should there be legislation on continued detention from Congress instead of allowing the executive to fill the void and make arguments?
Yeah, I mean, I think probably much more open than the other panelists up here to the idea of administrative detention, of an option other than prosecute versus release. That I'm much more open. I'm not 100% convinced of the need for it, but I'm much more open to the idea of an administrative detention regime. And I think that if we were to go that route, it would be one that would be better constructed with congressional involvement than through this continued back and forth between, as it's been largely between the executive branch and the courts. And part of the reason I feel that way has to do with my view of the law, which is I think this idea that the international legal tradition and the American legal tradition only contemplate prosecution as the procedural mechanism for long-term detention. I think I think there are many examples in international law and American law of detention without trial. My concern about the need for legislation is also driven by concern and observations about unintended consequences of trying to just pick out the detention piece of the counterterrorism puzzle and draw some absolute lines about detention authority. And to give a couple of examples, I think the European approach to detention in Afghanistan has been awful. The European allies in Afghanistan have essentially adopted a hold for 96 hours rule or release. And that rule is fine if you're European countries and you're backed up by American forces that are doing most of the detention there. But this European rule hasn't resulted in eliminating administrative detention. It has resulted in the Afghan government doing a lot of the detention on Europeans' behalf. Or it's resulted in the use of predator strikes to use lethal force rather than detention as the means of neutralizing terrorism threats. So I'm very concerned about the idea of adopting a prosecute or release approach to the detention question without considering how it fits in with a broader counterterrorism strategy, how it fits in with our interrogation policy, our approach towards coalition building and maintenance in Afghanistan and elsewhere.
Well, I'd like to get Nick's response to that because it is, sort of a third prong now, this notion of preventive detention in addition to release and prosecute.
Well, first of all, I think we need to remember the saying of Justice Jackson, if it was Justice Jackson, or Justice Holmes, if it was Justice Holmes, that law is not a suicide pact, and that one can't treat it as such. I'm very dubious about preventive detention, about detention, indefinite detention without due process, because I've worked too long in the government, and it's too subject to abuse. That isn't to say that a 96-hour and release policy is sensible. It doesn't, on the face of it, make any sense. But one needs a process for if people are captured, of determining whether they are shepherds wandering around by accident or whether they're unlawfully on the battlefield, in which case, with all due respect to the ICRC, they can be prosecuted.
I'm no longer with ICRC, by the way, so it's okay. Former ICRC.
I think one of the questions you asked a while ago was what are the issues if Guantanamo is closed and the detainees are moved to Michigan, which has been under discussion and mentioned in the newspapers, and the detainees themselves have gotten word about this and are not too happy because when they heard Guantanamo was being closed, they thought that meant freedom. And there are a lot of issues involved. There are security issues in which Guantanamo Bay is a very secure facility in terms of escape, in terms of being able to manage contact between the detainees and the outside world, being able to really control the conditions in the camps as best as possible, to focus on detainee protection and force protection, neither of which is a simple issue. It's an enormously complicated set of games that are being played there. And it's not self-evident that all of that could be done inside the U.S. typical prison. It's not clear to me. I don't understand why at Guantanamo, if a detainee assaults a guard, that's not a prosecutable offense, but in the United States it would be. So that's one whole set of issues. I don't understand why, if Khalid Sheikh Mohammed is under indictment, he hasn't been tried under that indictment. The hell with his role in 9/11. Al Capone was put away for tax evasion. Let's demystify this stuff. But I'm just a national security for an international lawyer. I'm not a.
If I can make a quick comment. Sure. In one of the comments was about how some of the detainees are in max facility down there. It's because of their behavior in the facility. It's a reward as far as which facility you go to and which jumpsuit you wear. It gives you internal freedom, and it's an internal control mechanism that every prison has. But it goes back to, frankly, you talk to the guys at Gitmo and they say, yeah, we can close Gitmo tomorrow. Bring in a big plane, put them all on it, and fly it to wherever you say it's going to go to. So down there, they could do that, in a snap. And then I like your research facility idea. I actually read that in the paper, and it's wonderful. But then where do you go here in the United States? And right now they're looking at all options. I think it would cost hundreds of millions of dollars, at least 100 and probably closer to 2 or 250, to take whatever facility you have that they're looking at, and then they would have to say in Time Magazine talk about Harding, Montana, this facility that's never held an inmate. And the town there put out a $27 million bond to build this facility because their unemployment rate is astronomical. You would have to take a facility like that and then extend the perimeter, and then build an airstrip, and then build some type of hospital facility, and et cetera, et cetera. So it's going to cost a great deal of money, which makes the January deadline harder, as Mr. Johnson, DOD General Counsel, noted that we're still shooting for it, but the closer we get, it's not just about the individuals and the looks, but the facility end of this is getting harder and harder to get close to that deadline.
And that focuses us on the bricks and mortar question. What do we do if we bring them stateside? And Michigan was one of the options. I think they were looking at a private prison facility that could be converted north of Detroit.
Well, they're looking at Standish, Michigan. And I can tell you that Representative Hoekstra, Republican congressman who's running for governor, has made a great deal of political hay on this. So
there's the NIMBY problem, not in my backyard.
Michigan's probably not going to happen because he's making such hay on this that it would have to go somewhere where more people are on board with the process.
In fact, Nick, I thought you were going to say the inmates were upset because they realized they might be going to Detroit. But back in my neck of the woods in Omaha, Nebraska, last year there were all kinds of rumors flying around because new facilities were being built at Leavenworth. And in fact, those were not in preparation for, taking Guantanamo Bay prisoners, but everybody in Kansas and Nebraska was in a flurry and rumors were flying around. So there is this problem. You know, what do you do with them if you do bring them stateside? And if you do bring them stateside, then suddenly, you know, they're physically in the United States, and Matt's problem becomes magnified of this idea of preventive detention. Can this notion migrate from preventive detention of foreigners to preventive detention of Americans once it's going on inside the United States?
I'd like to take a moment just to challenge Matt's assertion that Congress is the best branch to deal with the complexity of detention in, say, an armed conflict situation like Afghanistan, and the complexities of ensuring that we're building our ability to work with our allies and detainee operations, that we're fostering the rule of law and the perceived legitimacy of the detainee operations among the Afghans, and that we're working within a framework that the Afghan government can agree to, in a clearer framework perhaps than we already have. I think the Obama administration clearly believes that changes need to be made to U.S. Detention policies in Afghanistan, and they're taking a number of steps to try and increase the amount of process that's afforded. They're re-examining the legal framework for detentions, and clearly the concern about transfers to Afghan custody are serious, and a lot of them are human rights concerns about the detention. But I question whether or not Congress is the best branch to be making those kinds of decisions. If you look back at the language that was often offered by the chairman of the Senate Armed Services Committee, Chairman Levin, in 2007, that language would have applied to Afghanistan, and it would have created serious restraints on how the administration could go about working with the Afghan government to ensure that they have detention operations that are in accordance with Afghan law and that are within a framework that's agreed to and that promotes the rule of law in that particular armed conflict situation. In Iraq, where our detainee operations are now in line with the SOFA there, with the security agreement there, as they should be. They are taking into account local law. And the idea that we should have some overarching preventive detention regime that applies irregardless of the geographical location of where we're engaged in armed conflict, I think, I question whether or not that's a wise way to proceed.
Matt, do you want to respond?
Yeah, I mean, well, first of all, I find it very interesting how quickly views have changed about entrusting the executive branch to come up with good detention rules with the election of Obama. That said, I think Devon's point about restricting through legislation detention activities in battlefields is very well taken. Though the battlefield detentions in what everybody agrees, or not everybody, but a lot of people agree are ongoing armed conflicts is actually the easy part of the problem. I think that the tough cases for preventive detention are individuals who are captured outside of the geographical bounds of especially Afghanistan, but if you want to include Iraq as well, I mean, those are the tough cases for which I think the legal regime is actually in a state of ambiguity, a great debate, etc. So, and I'd also say that you could easily, if you were adopting legislation for preventive detention on a global scale, you could easily exempt from that active zones of hostilities, so that you'd give the president additional discretion if that's what you thought was necessary.
And this should be for non-Americans. Is that the idea? Is that where?
I think there's a good debate about whether you'd include U.S. citizens or not. I think there are good arguments both ways. I actually think it probably makes more sense if you were adopting this type of legislation to include Americans in that. I don't think I would draw a statute that only applied to non-citizens. Now, that may create additional constitutional issues that would have to be litigated, but
a couple at least.
I think there's a couple nuts and bolts issues here, and I actually do agree with Matt. Sorry, Devon, but that Congress should do this.
Devon.
So good. So that Congress should do this because Congress should have the debate anyway. So we should have an open debate in Congress, and that should be the conversation. Because, but I think there are really two issues. One is do we move forward with some type of preventive detention, National Security Act, something like that, going forward? The other one, though, is what do we do with the 226 guys we have now? And so I foresee a scenario where you get both, where to take care of those we have in custody now could be under some type of executive order. Going forward, Congress is going to have to get involved. If we're going to do this, yeah, Congress would have to get involved and move that forward. And we can talk about what some of the things they'd have to address. But I think so. I really think there are two issues going on here. I think there's probably the stopgap for what we have, who we have right now, and then who's the next person we catch after the next big event.
Okay, so Greg's sort of proposing a bifurcation. Nick, did you want to respond to that?
Not really. I just had a question. My recollection is that some years ago there was a State Department official named Wolf who was suspected of espionage, and he was not prosecuted, but he was watched. And I wonder whether we couldn't have a regime. Let's take the Uyghurs, for example. The Chinese have put enormous pressure on countries not to take the Uyghurs. If we, as part of the price we pay for this, for having screwed this up from the beginning, that we take the Uyghurs, can we surveil them, if you will, put them in a community or communities and just keep an eye on them? Because they've been trained to engage in terrorism, and they were eager to do it in China. So they're not nice guys.
What do you think?
But they're great greenskeepers.
And what we're talking about here is a release and watch type of program.
And
Devon?
I'm sorry. I believe that the plaintiffs themselves agreed to a number. I mean, we have mechanisms in the immigration context for that. Check-in mechanisms to track individuals that are released from immigration detention, immigration custody, and the Uyghurs agreed to those types of conditions. In the ongoing habeas litigation, there are a number of mechanisms that can be used, and there are also communities in the United States. I mean, unfortunately, it's seeming less and less likely due to the political climate that we will be able to take some of the detainees and resettle them. But there are clearly communities and refugee assistance organizations that are willing to take in detainees.
Well, and of course, the Uyghurs are in a little bit different situation because they've had a federal court say that they're not that bad, and the rest of the detainees don't really have that imprimatur. Last month, 4 Uyghurs ended up being relocated to Bermuda. Yesterday, it was announced that 3 of them are going to the South Pacific island of Palau. So they're not getting bad locations. China, though, still, Nick's point is, China is still leaning on countries not to take them. The Albanians took the first batch, and China froze relations with Albania and recalled its ambassador. And they haven't taken any more since then. Greg?
Well, when it hit the news that the Uyghurs went to Bermuda, one of my brothers called me and said, first of all, what's a Uyghur and how can I become one? So that was his question to me. But this is obviously very serious issues, and Devon raises an excellent point that, and I think Matt is in agreement, although I don't want to speak for him necessarily, but when we talk about some type of national detention act, I think it would be a full-ranging act like they have in England with the control orders, that you could go from kind of a watch probation officer kind of thing all the way up to some type of detention. So I don't think that whatever we produced would simply mean that these guys are locked up. So I think there would be a full range of items that a lot of European countries are using.
Certainly.
No, I was just going to say, but some of the draft legislation that scholars have put out, does really mainly only refer to detention. And I am thinking back, partly because of this was mentioned in the previous panel, when I did work for ICRC and was based in Geneva, I represented ICRC at the negotiations on the Treaty to Protect All Persons from Enforced Disappearance. And absolutely none of the Latin American countries wanted any exception in and for national security reasons. They would take any other language, which is, if you've been involved in negotiations or groupthink, that could almost be worse option to take other language than the terms national security. But because enforced disappearances and the abuses that were done because of or based on the claim of national security, they didn't want that language in the treaty whatsoever. So when we it feels casual to talk about a preventive detention scheme when we're also talking it outside of even the context of armed conflict. This is very serious. We have to be ready as Americans to accept that, well, if another country does a similar regime, and some do have them, that if an American's picked up, that's legitimate too.
Well, let's take a comparative riff on that question. What are the preventive detention policies in other countries?
Well, for England, for instance, uses control orders, and it ranges everything from probation officer type, what we would think of, to the ankle bracelet on up, and it depends on what the threat that this person poses and what their concerns are, that they'll apply for the proper type of watching, control. Well, that's why they call it control orders, right? Brilliant. So that's what they're doing. Australia takes a much more a shorter view, where you can detain someone for a few days and then you have to start putting together a better case. So they have a very small program. And then, of course, there's the Israeli program, which is a much more robust program. I know some people, when I say, well, what about the Israeli program? They say, well, we don't want to get into that. Because it is a fairly robust program, given their national security situation that they live under each day.
Well, they have a different set of threats.
Yeah.
Well, and I'd add to Greg's list, France, where individuals can be held, I think it's up to 3 years, under a regime of investigatory detention. They avoid the term preventive, but that's what it is as a functional matter. If you want to adopt, if we were to call ours investigative detention, I think that would be fine. I think we should worry more about what it does than what it's called. But I mean, I think that's yet another example, certainly in the European context, where the sort of absolutist position about try or release is actually much more watered down than the public debate would seem to indicate.
Well, and the other question, I suppose, that's coupled with that is, does prolonged detention, is that term coterminous with indefinite detention? Is it detention forever?
No. Any regime, any policy, any practice always has a review mechanism. And most review mechanisms have an initial review period of 96 hours or 14 days, but then it kicks in at usually a 6-month mark. So you can design it. Congress could design it any way they wanted to. They could have people looked at every 3 months, 6 months, but generally the accepted practice is, as long as somebody is being looked at every 6 months, you'd have to design what's that look, what does that mean, who's looking at them, is it a federal court judge in a FISA type situation, or as Glenn Semesi would talk later about a national security court situation. So there's other regimes out there on who would be doing the looking. But there has to be a continuous review on this.
Well, who's doing the looking? That's where the rubber meets the road. Sure. And over time, if you build up hundreds and hundreds and hundreds of people who are in prolonged detention, but then who are released and watched, you raise the question of what is the infrastructure for the watching, and are we moving ourselves into a Big Brother type of situation, Nick?
Yeah, I was just thinking that a good way would be to subject them to congressional hearings every 6 months, but that would be a torture. Yes, I think that for me it's interesting. I want to go back to a point made by our Iraqi colleague here. And the question of balancing security and law, and I don't see that there's a distinction, and that we in the United States, we're a country of law, and we have to do things according to law. I'm very doubtful about preventive detention, because what constitutes the grounds for preventive detention? And if you have probable cause for preventive detention, are you really saying you have probable cause to prosecute somebody for conspiring to commit, an assault or an act of violence that's illegal in some way? So that's just my visceral, untutored reaction, and it just makes me very, very nervous to think about this. It's a little like tenure. We're in a university. Tenure is really important. Why is it important? Because the country goes through spasms of McCarthyism from time to time, and you need to protect people's ability to stand up and say the emperor's naked. And if you do away with those protections, then or weaken them, then we're all in trouble.
I would also say my concerns extend to what goes along with preventive detention. Even if you can come up with a standard we all agree on, let's say we can. Well, most likely, since it's related to national security, this is all classified information. Well, does that mean the person themselves should be kept to a certain degree incommunicado, as we've seen mainly with Guantanamo? How far does that extend? And we know, and
talking about an Aung San Suu Kyi situation where we were talking house arrest.
Well, yeah, who knows what the conditions would be, but most often that has been the case, because if it's related to national security, I mean, that might be the claim. So what are the treatment of this person then comes into the issue. And I don't know if Devon was going to mention the report by the International Commission of Jurists. They had some...
Well, she is now.
She is now.
Yeah.
Segue, that, their study, the problem with such detention and the risk when someone's incommunicado is that there might be possible abuses that happen as well. It creates an environment that's able to...
Yeah. I agree with you. And Nick, I don't think any of us, and I'm sure Matt doesn't. None of us takes this lightly. I mean, this is would be one of the biggest movements in law in the United States in a very long time. Which goes back to why I think it needs to be full, open, public congressional hearings, et cetera. But it does go to intelligence, and I think both of you touched on it. And the difficulty now with the CSERTs and the ARBs, the annual review boards, administrative review boards, and the commissions is the intelligence. I'm just simply putting it out there as the problem. I'm not defending it. It's difficult in that, look, FBI agents, when they do an investigation, when they do an interview, it is not classified. It is for law enforcement use only, but it is not classified. That's their policy. That's how they do it. The CIA and all those other alphabet soup agencies over here are collecting intelligence for a different purpose. And so they're not doing what we, kind of that straight-laced FBI view. They're doing all the other things, and then you start looking at all the pieces and what do you do with it. And so any type of measures, your difficulty would still be with the intelligence. What do you actually show the person you want to hold on to? What do you show as lawyers? Who would be the lawyers? Who would be cleared to be the lawyers? Would they be government-appointed lawyers? Would they be military lawyers? So there's a whole raft of issues and problems that all come back to what Nick said about that intelligence.
Well, one take on this is that, part of the problem with Guantanamo is that we tried to legalize something that, shouldn't have been in that realm. It's and this is what, people have told me that have worked in the administration. When we went to war in Iraq, obviously it wasn't a legal war in the international law sense, so we tried to legalize it by, going back to anticipatory self-defense and that sort of thing. Yeah. And the same thing with Guantanamo Bay. We tried to legalize it. Oh, we'll do commissions, with the gloss of law on it, and that didn't work either, and now we're stuck with this.
Exactly. I mean, it could look tainted. I know Matt was speaking in broader terms than just Guantanamo, although the panel's on Guantanamo. However, anything that looks like it derived out of Guantanamo will be tainted. And it's, again, like the first panel discussed, well, okay, if we have enough evidence, we go to the Article 3 courts. If not, we get the military commissions. How does that look? So now we have to have this new preventive detention scheme because something didn't work with Guantanamo and why Guantanamo was set up in the first place and who was brought there.
And I think another problem of the dynamics of having an indefinite detention regime that was noted by the eminent jurist panel was that it creates a disincentive to use the criminal courts and to use a system that has the full range of rights that are afforded in the regular criminal justice system. I want to quickly highlight something that actually Senator Graham said quite recently in the last couple of months on the floor of the U.S. Senate, and that was, he said, this is a different war. This war will not end, and a determination that somebody could be determined held in death or could be continued to be detained could very well be a de facto life sentence. And that's really, that's the severity of what we're talking about. And that is why I think no matter how many reviews you have, whether it's a successive detention regime, as many countries have, where a court goes back and reviews the case and then says, okay, you can hold them for 6 months more, and then you can hold them for 6 months more, that it is indefinite detention. detention, particularly in the context of the way that the conflict is being defined, and the idea that you would sentence to someone to de facto life in prison based on intelligence information that couldn't be admitted before a court of law is really problematic and very troubling. I also just want to say that I do believe, I'm not saying trust the executive when I say that Congress shouldn't legislate. I absolutely believe in congressional oversight. We're doing, Human Rights First is doing its own factual investigations on the ground into U.S. detentions in Afghanistan, and clearly I believe there needs to be oversight when.
That's fine. If your concern, though, is the long-term indefinite life sentence, then that's a reason to have Congress legislate. Cap it. 3 years like the French law, successive reviews every 6 months with a maximum of 5 years. I mean, that's a problem that's solvable through legislation.
Yeah, first of all, I don't believe that the war in Iraq was illegal. I'm not going to sit here and let that go unchallenged. I've written an article on the subject. You can all read my views. The intelligence point is a very good one. I mean, the CIA statute used to begin, and probably still begins, notwithstanding any other provision of law, the CIA will do what the president asks it to do. And in 1945, a naval officer wrote a wonderful memo you can read in the Foreign Relations documents of the United States, which the State Department publishes every year, on the creation of the intelligence community, in which this naval officer said, of course we need an entity that will do what no self-respecting bureaucracy will do, and that's why you need a CIA, and you need the capacity to do these things, and that's why it becomes very, very difficult to mix the apples and oranges of intelligence and criminal justice. And that's why, and the justice system is, the whole incentive structure is wrong for national security issues, because it may be that if you're on the track of a spy or a terrorist, you want to watch the person for a long time and never take any action, but always watch, because you want to see what the network is and where it all leads. So that's not classic law enforcement work. So there are a lot of different issues here. I remain unconvinced by the preventive detention arguments. I do think long-term detention is a real issue for real POWs. The Moroccans have got Western Sahara people been in POW camps for 25 years. I mean, it's a horrific situation. Like, there's been no combat for years. Nobody can agree on how to release these people.
Yeah. Devon?
I just want to quickly respond to Matt's comment in that it was Senator Graham, who is, and to just talk, I mean, we can talk about indefinite detention in the abstract, but I do think it's important to consider the realities that we would be legislating in, because there are members of Congress considering this now. There is legislation that has been introduced, in the past couple of years that would provide for continued detention, and it was Senator Graham who said that, in fact, you could detain, under any law that he's likely, and we know that Senator Graham is a key player in this debate, and that legislation is unlikely to pass without his support. He's saying, I'm conceiving this as being a detention for life, possibly, and that's how he's conceiving it. How Chairman Levin is conceiving it, at least in the legislation he proposed in 2007, is you wouldn't even get a review under that legislation until you've been held for 2 years in U.S. detention, and coerced evidence would be admitted. So I think it's important to actually consider, when you're advocating for Congress to act, what you're likely to get back from that request.
Well, that's fair. I mean, I certainly wouldn't defend bad preventive detention laws. There are a lot of proposals out there that I think would be worse than what we have now, and I think there are some that would be better. I think that's why, if we were going to go the legislative approach, I think we'd want to do it after a lot of consideration, not just of these kinds of legal issues, but also strategically, where is it that detention falls in our broader counterterrorism strategy? I think that's an issue that's been certainly underexplored in the public realm. It's sort of assumed that you capture somebody, you incapacitate them through detention, and that therefore improves our security. Whereas Devon and others have argued, I think persuasively, that over-detention, casting too broad a detention net, can actually be counterproductive from a security standpoint. So I would certainly agree that we need to be very careful in how we calibrate it. I would also, though, say that just as going the congressional route opens us up to the possibility that we'd get bad legislation, failing to go that route also opens us up to the possibility that we will get bad detention law through the executive branch or through habeas courts figuring this out as they go with very little statutory guidance. I think that's a danger that we're open to either way. And just as, and I would finally emphasize my point from earlier that as you take some of these options off the table, like detention, don't pretend that the problems go away and that anybody who ought to be incapacitated long term is going to go into the criminal justice system. Many of those people will will be, I think, transferred to third-party intelligence services for interrogation abroad. And again, perhaps another reason why you'd want Congress to look at the whole ball of wax and try to rationalize our detention policy and counterterrorism authorities, or we use other mechanisms like lethal force. So I would certainly agree that there are these unintended consequences that we need to be careful of if we go a congressional preventive detention route. But we're facing many of those concerns now, and they certainly don't disappear if we adopt an absolutist position against preventive detention.
And of course, you're only talking about this in the counterterrorism context.
Yeah.
You're not talking about it bleeding out into use for other purposes.
Sure, and I think that is one of the dangers of a national security preventive detention scheme. I mean, one of the issues that I raised earlier is, detention without trial is not a new concept in American law. I think it's often part of the public narrative, but there is detention without trial for pretrial arrestees under federal bail law. There are preventive detention for sex offenders in the immigration context. Put aside all the law of war exceptions to this general principle of prosecute or release. So the question is, does creating a new exception to that general baseline principle create some dangers to rule of law, democracy, et cetera? And it may be that that those dangers are heightened by adopting this type of statute in the national security context, because as Nick was alluding to earlier, there are incentives that bear down on government officials to take aggressive action in the context of national security threats that I think are unlike pressures that face government officials in any other context. So there are some unique dangers in this context, but we shouldn't pretend that this is a new radical departure from an absolute prohibition on detention without trial in American law.
I would also say that there's the ubiquitous danger of politics.
Absolutely.
I mean, every high school civics class student learns that you're innocent until proven guilty, and they don't learn about detention and preventive detention. And so if they don't go to law school and learn that, then that's going to offend their notions of what it means to be an American. And you can't be picked up off the street without trial. And there's a political backlash for that. And politics may rend that seam asunder as completely a non-starter.
And isn't there a recent, I mean, some of the, what we call preventive detention and the examples you gave, that there's been abuse of those as well.
Absolutely.
And so
there's
been
been abuse in the criminal justice system, too.
Right. Yeah. But without the same...
Any detention law, including criminal justice law, is open to abuse. And I think...
but criminal justice might have a different review mechanism and accountability mechanism.
So add those to preventive detention. That's why you would have continued court review. And I'd say, again, a problem with relying on habeas, as goes on now, is habeas is generally a one bite at the apple procedure. So if you believe that detention ought to be overseen by courts, then that's a good reason to seek legislation that would have continued review by those courts instead of one shot at a habeas apple and then it's just executive discretion.
Well, yeah, you would be altering Article 3 court duties. It's time to throw this open to questions from the audience. And I see one or two hands. We'll start with Jordan because you were so nice to defer the last panel. And you're practically up here with us on the panel.
I agree with Nick. Since my ancestors signed the Magna Carta, I think that liberty is terribly important American value, and the Constitution's at stake, not just the legislative branch. But I wanted to ask a question about the detainees that we presently detain. With respect to an international armed conflict, it's well known under Article 49 of the Geneva Civilian Convention, if you have a person who's not a prisoner of war, I don't think anybody at Guantanamo is considered to be a prisoner of war. You can't transfer them out of occupied territory. You can't transfer them out of Afghanistan or Iraq. It's a war crime. It's not only a war crime, it's a grave breach of the conventions. So why isn't that part of the formula that people are considering concerning detention? And how would we resolve the war crime that was part of the Bush program of transferring people out of occupied territory who were not prisoners of war? Internment must take place under Article 78, I think it is, in the country where you capture them. So, I mean, we can't transfer a person up to Michigan. Do we have to transfer them back to the occupied territory where we brought them?
Straight up Geneva question.
I think we just built a $73 million facility in Afghanistan.
Well, and one of the things we didn't really talk about, that's one of the things we didn't really talk about as an avenue, and this is probably reserved for panel number 3, is the possibility of a hybrid international criminal tribunal, an ad hoc tribunal, maybe in Afghanistan, as an avenue to transfer people to. But anybody else want to weigh in on the straight up Geneva question on the illegality of transferring prisoners or detainees out of occupied territories?
Everyone's
They're looking at you.
Yeah. I pause just because, is it an international armed conflict? Is that provision applicable? And so sure, civilian population should not be transferred out of an occupied territory according to Article 49 of the Fourth Geneva Convention. But I'm not necessarily sure to what extent, given the transition of the conflict to non-international armed conflict, that you couldn't have some persons, if they were originally combatants, that were moved out. Granted, there are certain restrictions, but I'm not sure how far that would apply now.
And it's my recollection that that provision was designed to prohibit practices that took place during World War II of massive movements of populations throughout Europe.
It's referring to the civilian population, though, isn't it?
Right.
Right.
But I believe that's the origin.
It's understood that persons who are not PWs are covered under the Geneva.
Oh, and so you're saying since they weren't given POW status by Bush, then they had to have been civilians, therefore they shouldn't have been transferred out. Okay. Okay.
The Army Field Manual.
Right.
That's still operative.
Yeah.
That if you're not a prisoner of war, you're protected under the Geneva Civilian Convention.
And I would agree, which
There's
was
no gap in coverage.
Yeah, and I would agree with that. There is no gap.
That's a whole separate panel.
Right.
On whether there's a gap in coverage.
It was the first panel. It was said that there was a gap by someone in the first panel, and I would agree with you that there is no gap. But I'm sorry, I was presuming then that if they were captured in the international armed conflict, that they were then POWs and not civilians. So that's why that's the way I did it.
All right, next question. Yeah. There's a microphone coming.
Thanks. I have a question on preventive detention, since that took up a lot of the discussion. Let's assume that whoever we're holding preventively, someone we don't have rock solid evidence against them to use in courts or in some kind of a military commission, yet we have some doubts that they may engage in some questionable activities against U.S. interests, and so we choose them. We have some kind of a preventive detention scheme. We choose to hold them. So one option, as Devon mentioned, is de facto life sentence. Basically, we just extend the preventive detention. But let's just assume that, like some of these Guantanamo detainees who were cleared, let's assume that we hold them for 5 or 6 years, some long period of time, and maybe the facility was nice and maybe they got, dental care and good food, but still it's pretty horrible to be, detained if you, don't think you did anything wrong. And now, basically, we release them, right, because, that's now our policy. Aren't we basically creating a greater risk to our national security by releasing them, because ultimately they now may be much more inclined to engage in terrorist-like activities against the United States, because now they really may hate our guts after we held them, for so long, and they may not even have known, why we held them.
I think there's a couple.
So that's the chickens coming home to
Yeah,
roost,
I think there's a couple points there, and plenty of people have said that. Maybe the guy wasn't a terrorist going in, but if you hold him for 5 years and he goes home and find out his wife is married to the guy down the street that he hates, and well, maybe he's got nothing to do with his time at that point, so he, joins the movement, right? But more importantly, I think what's illustrative of what you're talking about is what we're actually doing, and well, not doing now, but had been doing for several years down in Gitmo, the administrative review boards. We had up to almost about 800 people there. We're down to 226. Those guys didn't magically disappear. They went through a process, and the administrative review boards, over an annual review board that took place, looked at them and reevaluated each in a full hearing that the person came in and could say anything. They could present any evidence. They had a representative. It wasn't a lawyer, but they had someone trying to help them, and they went through this process. And that's how the vast majority of the people who were sent home from Gitmo were sent home, because the ARBs released, set them up for transfer. And it went up through the process, got signed off, and they got sent back to maybe sometimes home, maybe to a third nation, because, they couldn't go home. It's the Uyghur problem. China, of course, wanted the Uyghurs home. Here, kitty, kitty, kitty. So they wanted them home. But we're not going to do that. So we had that situation with a few other countries, so they had to go. And our track record there is pretty solid. And the people that went through the ARB process and then were designated for transfer and went home, the recidivism rate is extraordinarily low, much lower than U.S. criminal population of recidivism rate. So the track record of what we did in the ARB process it could be illustrative of what this process might look like.
Well, but I think there it brings up the question, though, what is the standard again for detaining people? And let's presume it's armed conflict, which is what the habeas court, in the habeas cases, the courts are assuming. I know we were beating up on Matt a little bit earlier, so I'll now be nice to him and say, yes, it's true. It's very interesting what the courts are doing, because when they review these cases, because there's two standards they were using at one point. One judge adopted the Bush unlawful or enemy combatant standard, and then Obama, another judge asked President Obama once he came into office to give us clarification on that. So then there's another standard, and then the judges have interpreted this new, can I call it the Obama standard,
yes,
in different ways. So different judges are applying the different standards, and in fact it even gets more interesting, because one judge has actually said, looking at the AUMF, I'm not going to review the initial determination of detention. I'm going to look at whether someone should continue to be detained now, which is actually very similar to the type of review that should be done for any civilian that is interned under the Fourth Geneva Convention. It's looking at now, at this point in time, can we still keep you interned? All the other judges are looking at the initial detention determination. It would seem, regardless of the circumstances, that have the past 7 years.
Just for a point of clarification, the ARBs are reviewing should we continue. They're not looking at the initial part. They're looking at the threat level and whether or not that person can be released.
And it was the judge, Judge Huvel, who is reviewing the continued detention versus the initial detention. She based it not only on the AUMF, but also the government practice law, and the fact that, well, they had the ARBs, the ARBs. I guess that's really what we should be doing, is looking at the continued detention. It'll be interesting how this all plays out in the end. But
okay, next question.
Yes, with regard to the detainees that we have right now, and also the idea of preventive detention, I think we have another indefinite issue. We started out with an indefinite conflict, right? And then we moved from the indefinite conflict to this, indefinite detention, and now we have this indefinite revision of law, where we're going back ex post in a way that, as an attorney, I continually think this is somewhat unconstitutional, and redefining what's right and wrong after the fact. And I'm concerned that if we keep doing this, eventually we'll get the law just right. So it's just so that we can hold people accountable for what we want them to be accountable for, rather than for what justice really requires. Thank you.
What do you think about that? Indefinite rewriting of the laws.
Well, if I could just give some examples from what the district court, D.C. District Court is doing in the habeas cases. I mean, despite my criticism to a certain extent that, you know, depending on which judge you'll get a different standard, they've actually done an admirable job with interpreting the law of armed conflict. I'm not necessarily going to say perfect, but they've dealt with some very complex issues. Granted, they're only reviewing whether someone's analogous to being a combatant, but let's say the government has the authority to also detain intern civilians. The government doesn't have to use all of the authority it has, so it could decide just to intern the people that meet the definition of combatant. And so figuring out what a combatant means in a situation that's not an international armed conflict, so we don't really have a clear definition, brings up other very complex issues. Are these combatant-like people, or is everyone still a civilian? So even if it seems that they're remaking the law, maybe some of it they are getting not badly, at least vis-a-vis protecting and maintaining the standards of international humanitarian law. But I do still take your point that, wait a minute, how many times do we get a bite at the apple till we get it right, and maybe there's no more review, but it doesn't mean international standards.
Devon?
And we're talking about, and I think this is what you see some of the judges getting very frustrated about, is that you're not just talking about keeping an attempt to improve the law. You're talking about individuals that are remaining in detention while you continue to try to change the law again and again. You know, we bring them into custody. They're there for years before they get any process. Then you try the CSRT process, the Combatant Status Review Tribunal process. And then the Supreme Court says, well, that's not enough. So now they go into the habeas process. And now maybe we're going to have a different congressional established standard for trying them. And then they're going to go into that process. And throughout these years, you know, the detainees have been in custody for over 6 years. This is 6 years of individuals' lives. And I think you will see an increasing, I would expect that the judges are likely to have less tolerance for that going forward. I think from their statements, from their opinions, they clearly recognize, and from Boumediene, they clearly recognize the urgency of the situation and are going to have less tolerance.
And there's also the potential for reaping the litigatory whirlwind. I mean, you know, the ones that we've released from Guantanamo Bay have signed all these statements that they're not going to sue us, but just wait. Just wait. Yeah, another question from the audience. Yeah. There's a microphone that's coming down.
Yeah, in the context of Guantanamo, you know, a lot of people have brought up the issue that maybe worse things have happened at Bagram, but because it's physically located in the country of conflict, therefore it has sort of got the pass. Or is that a model that's going to replace Guantanamo, or are we going to seriously look at, you know, what's happening at Bagram, and how should facilities like that be controlled in future?
Okay, so this really goes to a comparative legal status of Guantanamo Bay versus Bagram Air Force Base in Afghanistan. Would Article 3 courts have jurisdiction there?
Well, we're going to find out, aren't we? I mean, one court has already said, at least for a certain category or types of individuals that were brought to Afghanistan from somewhere else, one court has said, yes, habeas should extend because it's Guantanamo-like, and we don't want the government to circumvent the habeas by sending people to Bagram. But obviously that's being appealed by the government, and we'll see how far it extends. I mean, I think coming from a background of being a law of war lawyer, I do take to heart some of what was discussed in the first panel about we have to balance and be careful of the balance that the law of war does create, of why we have certain rules the way they are to maintain humanity during a horrible situation, but still allowing war fighting to occur. I mean, if the laws of war start making it impossible to fight wars, then basically it's jus ad bellum, no longer jus in bello, and obviously all humanitarian provisions risk to be undermined because no one will respect them. So how does that play into how you're going to be able to do war fighting if habeas extends? I'm not saying that it shouldn't extend. I'm just wondering and ask these questions. I mean, it's the same questions I would ask with the D.C. District Court when they're interpreting the law of war to apply on who they should detain or not. Sometimes I would say they maybe sweep or risk to sweep broader than the law of war would allow on who you can intern. Sometimes they risk on interpreting the law of war to sweep too narrowly. And that could also have negative humanitarian impacts if it sweeps too narrowly in some circumstances. Again, it was mentioned by the first panel, where we don't want everyone then to be killed because governments can't detain them.
It goes back to exactly what Nick said at the beginning. He said we do not want our soldiers to stop taking prisoners. We don't
Nick
want to
also
get to that
said
breakdown.
send everybody back to Afghanistan, right?
But I also want to highlight that clearly now in Afghanistan, now that it's a non-international armed conflict, humanitarian law is not the only international standards that we need to be considering. We need to be considering the obligations under international human rights law as well, and particularly under the International Covenant on Civil and Political Rights. So, and that doesn't necessarily mean that all detainees need to be brought back to the United States for review before a U.S. court. There are possibilities, and it's clearly the U.S. is trying to build the judicial system within Afghanistan so that they can handle review of some of these cases, and so that that review process can take place within Afghanistan. It would obviously be preferable, I think, to include Afghans in that process of review of detentions in Afghanistan, both for the perceived legitimacy of our detainee operations and our other military operations as well.
I just wanted to say that I do not agree that the conflict in Afghanistan is per se a non-international armed conflict at all. I think that there are plenty of aspects to it that involve foreign countries, bases in foreign countries, people crossing boundaries, support for various armed groups. The United States is there, both under Article 51 and in support of the elected government of Afghanistan dealing with an insurgency. I just don't buy it. And I know that's heresy in a lot of circles, but I wanted to raise a cautionary flag here because one can, as I said at the beginning, one can get wrapped around the axle of these categorizations and trying to decide what law applies, and ultimately forgetting that one is dealing with a situation where the presumption should be that anybody captured is a POW unless you can show the person is not a POW, in which case other measures can be taken. And that's just a useful rule, because the soldier, the boot on the ground guy's got to know how to behave, and he can't sort of say, "Jesus, is this an international conflict, a non-international conflict? Which rule apply?" And it's the United States is not party to the 1977 protocols, which is very important to remember. So,
I would just add that the qualification will determine which rules apply. And it's true, you can start having a discussion with someone where you're talking past each other quite quickly if you don't even agree on the qualification of the situation. And this has been, going on for a long time, particularly somewhat in Iraq, in Afghanistan, but then also on the formerly called global war on terror. But it will have to be qualified, because otherwise we don't even know what rules we're talking about in the first place. Now, again, for the soldier on the ground, we don't have to necessarily speak in those terms. But obviously, in determining what international obligations exist, we have to. And
well, that's why the JAG officers parachute in with them.
Exactly. Or the ICRC's there, too. Okay, my former employer. But I do think at least the Supreme Court made clear that it's not an international armed conflict there. Again, we can discuss this, and there's lots of debate. But
Supreme Court doesn't know what it's talking about.
Well, I'm trying to give up. Okay. Then I can, if we're not going to listen to the Supreme Court, then, I can just discuss that.
You have to listen to the Supreme Court, but no, it's ruling in the death penalty case, the Medellin case. Showed the folly of bringing a death penalty case to the Supreme Court that involves very important questions of the relationship of international and national law and U.S. international law obligations. And came out with a very weird set of pronouncements on the subject that's going to take a long, long time to straighten out. And with some respect for the ICRC, this issue about how you categorize it categorize a conflict as international or non-international is so freighted with the ICRC's particular political agenda and human rights first particular political agenda. One needs to keep that in mind when one is discussing this.
Okay, I don't know what the political agendas are, and I'm not trying to defend ICRC. Okay, I'm just saying I'm not sure, because I think also the former administration had an agenda too, and how that qualified. But I think everyone just keep in mind it's the treaties themselves that say in the articles of the treaty when they apply or don't apply. So everyone at some point, if they're going to apply, the government's going to have to qualify it.
Well, we can agree that everybody has an agenda.
Right.
And Larry May has an agenda with a question. There's a microphone coming down to you, Larry.
This is really a comment, I guess, about a couple of things that have been discussed. So about the precedents for preventive detention, I think it's important to point out that if we think about the three examples that were given, for sex offenders, for instance, it's horribly controversial to do this, of course. It's even more controversial than Guantanamo in some respects. And even there, it's different because those folks have already been adjudged to have committed a crime, have served their sentence, and only then are we thinking about having this preventive detention. That's very different from the Guantanamo case. The immigration law offenders, even more controversial than the sex offender cases, I would think. And so... And as far as awaiting trial goes, the people who are awaiting trial can petition for a speedier trial and get out of this particular impasse. So I'm not sure that those cases are actually good precedents for talking about a preventive detention option for Guantanamo. Second comment is about the habeas and one bite of the apple. Well, my understanding is that's only true since the late 90s, right? I mean, it used to be the case that successive habeas petitions was the name of the game, and that was true for, as far as I can tell, hundreds of years. So it's only been in the last decade that habeas has been restricted that way, and I would argue that that was a big mistake that was made then, and so we could still use the habeas model as long as we look back 10 years rather than to the current.
If you went to Congress and got legislation that would provide for that kind of federal court jurisdiction, which brings me back to my point of why I think if you wanted to solve this problem, ultimately you are going to have to go to Congress. With regard to the precedence of preventive detention, I agree completely with you that all the examples that I cited are very controversial. I agree with you that all of them are very, very narrow exceptions that are laden with all kinds of factual predicates, et cetera. And I think the same thing would be true if you adopted a terrorist preventive detention, whatever you wanted to call it. So none of them provide absolute precedential support. None of them are free from controversy. My main point was simply that I think the alternative narrative that the American legal system has always been built on this idea of no deprivation of liberty without full criminal trial beyond reasonable doubt is not accurate historically, and that if you were to carve an exception to that, the whole fabric of American law would unravel, because that hasn't happened with these other examples in the past. There are reasons, as I say, why a new exception in the terrorism context would perhaps be more dangerous, and that worries me a lot. But I merely want to point out that the narrative is not a simple one.
Well, I don't know what other examples in the narrative you're talking about. I mean, I know about the internment of American citizens of Japanese descent during World War II, which was preventive, was outrageous, blessed by Earl Warren as governor of California and Hugo Black on the Supreme Court. So it shows how people of outstanding reputation get things screwed up. And the Bush administration got a number of things screwed up for good, bad, and indifferent reasons. But I think Professor May's point is really a good one, and I'd be interested in knowing what the other examples are that you're pointing to or have in mind when you say that the U.S. historical record has a number of instances of...
A good one, I think, would be individuals who are involuntarily held for reasons of mental abnormality or mental illness that poses a great danger to themselves or others, which the Supreme Court has held. Those individuals are entitled to a judicial hearing. I think the standard of evidence is clear and convincing, but it's not beyond reasonable doubt. It's not full jury, etc. And similar. So I mean, there are precedents for administrative detention with judicial hearing for reasons of dangerousness, but not criminal justice.
And we'll let the audience decide whether that's apples and apples or apples and oranges.
And I don't argue that they're apples and apples. I just argue that they're out there and bear some analogous value.
Lunchtime draws near, and I'll take the chair's prerogative and invite you to continue this discussion in January. I'm hosting a Guantanamo panel at the American Association of Law Schools annual meeting in New Orleans. So if you come to our national security law section, you can continue that. And also continue watching. You may not have heard yesterday that the prosecutor for the International Criminal Court has said that he will begin investigating NATO war crimes in Afghanistan next year. So we're going to see if, in a reverse situation, what's good for the goose is good for the gander. Please let me help thank the panelists.